morning, everyone. Special episode today. Good morning, Frank.
Good morning. Good morning. How are you?
I'm good. And Ron, we are joined by Ron Coleman. Ron, it has been a while since we've talked.
It has, but boy, what we accomplished last time we talked, then you went and burned your house down.
I know. It's a shame.
So please don't have that kind of reaction this time.
I didn't know that's what happened before.
Oh yeah, that was the order, and I always assumed that it was cause and effect. I don't know. It seemed obvious to me.
Oh man, this whole story is taking on new meaning to me now.
You would be surprised how many people out there decide that they're going to be wise asses and say, I burned my own house down, because that's really just what people do nowadays. They don't.
No, but especially after they make a huge investment in building it out and building a studio. Yeah, that's the move. That's the move. Especially because we know insurance companies are so awesome.
They do. They pay out way more than you ever could. You never even have to argue with them for it.
Right.
Hold on, I'm having another issue. People are saying my mic is low. Here we go. We're going to raise this up. How is this? I don't understand why this is happening.
Wing low.
Yeah.
Very moody.
I don't know why this happens. Everybody's like, sound. There's a 4-second delay. Hold on. Can you hear me now?
Yes.
You guys can hear me. I'm waiting for the audience to respond. Better? I know.
Oh.
I really said it. I know why. Hold on. I said it the wrong way. There we go. Now it should be even. You guys talk.
Hello.
Frank, man.
Hello. Yes. Yes. Did you see the game last night, Ron?
I did not see the game last night. Was it in a sport?
Yes, it was a baseball game.
Well, I love baseball. I just don't follow it anymore because I was a big Yankees fan growing up. My father was a Yankees fan. Did you ever hear about the time Mickey Mantle? Yes, Mickey Mantle. This is how far back. Actually, my dad saw DiMaggio play.
Oh.
Wow.
At the end of his career. Yeah, it was always always made it clear to me it was at the end of his career. But he was at the stadium one of the two times when Mantle hit the old
light
facade.
tower.
Not the old facade over, that went over Yankee Stadium. And in those days, every game wasn't sold out. So it was like a day game. And maybe there were 15,000 people in the stadium. And he said that the second the ball left the bat, Mantle's bat, there was no question that it was out. And all anybody was wondering was, is someone finally can hit a ball out of Yankee Stadium? And it was so quiet that you could hear when the ball hit the facade. It was like clank, and then the place went nuts.
Jeez. To think about the history that you were able to see just in your backyard if you lived in New York, and like you said, it was never fully sold out unless it was a World Series game. But yeah,
even World Series games were sometimes not sold out. It was it was some people. The idea of a 2 million attendance season, I remember in the 80s began to take up steam, and now it's listen. I should have stayed in. I should have stayed in baseball, but heel spurs. No, of course I'm not.
No, that's
Ron Coleman with the baseball bat. All right, so share this out with your friends, guys. Make sure that you like and subscribe and all the things. This is actually, the sound is good now, so we're good to go. We're going to do countdown for actual podcast, audio podcast. 3, 2, 1. Good afternoon, everyone, and welcome to the special Wednesday edition of the Dark to Light podcast with
Frankie Val on the drums and
Beans. We're joined for the first half today, which will be a longer show because remember, we don't have a show Friday, Frank, so we're giving them an extra half hour today. We're joined by Ron Coleman. He's an attorney. He's a pundit extraordinaire. He's a good friend. And he's also now partner at Dhillon Law Group. Is that correct, Ron?
That is correct. I don't know for how much longer, but I
What?
Well, I listen. We have a nice thing going, and Harmeet has really built out the firm very nicely in the last couple of years, and I'm looking forward to finishing my career here and hopefully not in the near future.
Okay, so we cleaned that up because I was confused for a second. Hey, listen, you never know. You break news on this show, it goes. But you have a case that I was very interested to talk to you about right now, and it ties into so much of the other stuff that's going on. And Frank, as he said, is going to do, what did you call it? Color as who? I don't.
Color commentary.
Like Susan Waldman.
I'll be Susan Waldman today. Not only that, but like I told you before.
But which one of us is John Sterling?
I guess you guys are going to have to be like a two-spirit. I'm going to be Susan Waldman to both of your combined energy. But the other thing really is that aside from me wanting to learn a little bit about what we're talking about today, the power washer guys just showed up to start pelting the side of the house. So I'm going to be muting a little bit more as to not
we
destroy
don't hear a thing.
Okay, well, it hasn't started yet. But go ahead.
All of a sudden, you're going to hear the engine. Okay, so, Ron. Rogan O'Handley is suing Twitter, if I'm not mistaken.
Twitter and the state of California, basically. I mean, it's the Secretary of State, but yes.
Please explain, because this is one lawsuit I actually haven't read in depth. So please explain to the audience what's going on in that suit.
Well, of course, one thing you do know is how most people know Rogan O'Handley. DC Draino.
Yes,
DC
on
Draino,
Twitter.
he has several gazillion followers on Instagram and hundreds of thousands of followers. Maybe he's up to 1 million now, I don't know, on Twitter. But he was off Twitter for a while. And he was off Twitter for a while. You know why? Because the government told Twitter to take him off.
Mm-hmm.
That's a problem. And it's exactly what happened. I don't know if you were at all paying attention to the election in 2020.
I actually skipped that one. Sorry.
A little bit. I was sleeping through most of it.
Yeah, I know. And I think also there was a pretty good World Series that fall, and it just took a lot out of us, you know.
Yeah.
But there was an election, and it was a highly fraudulent enterprise, and I'll stand by that as long as I live, because I was in Philadelphia on behalf of the Trump campaign as part of my duties as a member of the Dhillon Law Group. And I saw them refuse to comply with a court order allowing observers into the convention center in Philadelphia. When I say I saw them, I mean I was standing 3 feet away when the lawyer for the Board of Elections told us, I know that you have an order, but we're not going to obey it. Because they knew that the Pennsylvania Supreme Court which is an entirely political body, would overturn that order, and said no. When the statute says that people are that the opposition party to the party that runs that district are allowed to watch the counting of mail-in ballots, it doesn't mean they have to be able to actually see them. Watching just means that you can just know there are people in a room and they have paper in their hands. So that's Pennsylvania for you, but a different topic for a different episode. And I will be you told everyone that I'll be on a weekly basis here, Tracy. Yeah.
We'll gladly have you.
Oh, let's see. We'll see how the ratings are for this one.
Okay.
The streaming of advertisers. I heard Bud Light, by the way, is fantastic. I don't know if. Anyway,
we were going to take a douche company, so Bud Light is nothing.
Yes, I suggested we go through. I suggested we do either Summer's Eve or Messingill.
So anyway, Rogan had some things to say about this, and he was flagged by a consortium of secretaries of state, all of whom were Democrats, operating through state secretaries of state, of course, operating through the Association of Secretaries of State, who hired a firm called SDK. Perhaps you've heard of it. It is a big consulting group that is at the center of almost all Democratic Party shenanigans.
They do PR too, right?
They do PR, and they are very, very big in the woke, in the Me Too movement, and there are stories to tell about them as well. But they flagged Rogan O'Handley. They have a special terminal. I mean, all this now some of this is unremarkable because of the Twitter files stuff that's come out, because everyone knows about it. Except so far, everything that's come out, and there is a Twitter files team member that I have an outstanding call to that I need to follow up with on this. Almost everything that's come out so far has been about the federal government and the intelligence agencies essentially running the censorship operation at social media companies. This was a state-based effort, although it seems extremely likely, if not certain, that they were coordinating with the feds.
I have something for you. From
Thank
states.
you.
You're welcome.
Oh, good.
It was Katie Hobbs when she was...
Do pass it along.
Yeah, she was acting Secretary of State of Arizona, and she personally, her office emailed Election Integrity Project working on behalf of CISA to censor somebody on social media. I will provide that to you after the show.
Thank you. Yes, that coordination is a big deal, and that's going to be very helpful to us if we can get the case back in front of the court. Because what happened? We sued Twitter. Let's be very clear. Let's have a little quick lesson in constitutional law. The government may not censor speech. Private companies, in most circumstances, may censor speech in most places. We know they can't censor speech along common carriers, right? In other words, Verizon can't say, we're not going to permit you to have this phone call because you're talking about hydrochloroquine. They can't. It's a private company. Well, it's a regulated. No, these days it is, right?
Yeah.
Right. It used to be a utility. That's how old I am. I was just in California and I was seeing all the old Pacific Bell things. Bell system. I'm an old guy. Anyway.
I remember 9X. Do you remember 9X?
Yes, 9X.
Up here.
Very good.
And Frank is like 40 years younger than you, Ron.
Well,
I'm just observant.
I'm just kidding.
Well, there's observant and there's observant. So all right. So we sued Twitter because Twitter is not a common carrier, but what they were was a government actor. They were essentially working for the government. Now, there are two theories of working for the government. There are two approaches. One of them is the government made you do it. And one of them is the government, you are paid by the government, or they outsource their censorship. Well, it's outsourcing in either event, but either you do it voluntarily or involuntarily, but either one is prohibited. We filed an extremely detailed complaint, which was backed up by a great deal. Oh, I skipped a step. They banned DC Draino from Twitter. The straw that broke the camel's back for them was a claim by this consortium through the special portal that the state actors are allowed to use, the bat phone basically for Twitter. Mm-hmm. And they said this tweet where Rogan says California's election process is completely fraudulent and completely corrupted. A full audit is needed. They passed that on to Twitter and said, this is a threat to election security. Let's think about this. His expression of an opinion
is a threat.
Is a threat to election security.
Mm-hmm.
He said it in January.
After the election?
After the election.
Oh, goodness.
Okay.
And guess what? We got the smoking guns from a Judicial Watch FOIA request. But it wasn't FOIA. It was the state version of FOIA in California. California, or whatever it's called. And we had the receipts. So this was an unusually detailed and well-documented complaint. We had to file it ultimately, or it had to be litigated in the Northern District of California.
Yeah.
Foreshadowing, because any time a social media company is, or any technology company, but certainly a social media company is sued in the Northern District of California, they will not lose.
Yeah. Yeah.
That's the deal. So we went through this very exquisite oral argument, which was handled by my colleagues at the Center for American Liberty, which is this great nonprofit that is helping us fund the litigation. And the judge then came out with an opinion about 6 weeks later and said, well, yeah, but I don't really see the connection. I don't really see the connection between this email that says ban them and they're being banned. Really? And the percentage that was bragged about by the California Secretary of State and the other secretaries of state was that the takedown rate when we request that Twitter take action is over 98%. I don't see the connection. Guess what? It's not for you, Judge, to see the connection. It just has to be a plausible claim.
Yep.
A jury is the one that has to decide if we prove the connection. And we do that by getting discovery.
Not only that, but don't they have to take your allegations as true in order to litigate on a motion to or to decide on a motion to dismiss?
They have to be true, but under the test enunciated by the Supreme Court in the 90s, which tightened things up a little bit. It has to be true. They have to accept the allegations as true, but they have to be plausible.
And you had an email.
We had more than an email.
Yeah.
And the judge said, well, I don't think that's good enough. We took that to the Ninth Circuit, and the Ninth Circuit absolutely punted. They didn't punt it. They just said, well, maybe election security. I'm like, they were all over the place. But what they didn't address was how is the judge making a determination of credibility here?
Yeah.
He's not supposed to do that even on a summary judgment motion, much less on a motion to dismiss other pleadings. So Rogan instructed us.
Who's also a lawyer.
Rogan is a lawyer. He went to the University of Chicago School of Law, which is one of the top 5, in my view. Instructed us that rather than go through the conventional approach to seeking a rehearing from the entire Ninth Circuit panel, he wanted to go straight to requesting review by the Supreme Court, which is a riskier but potentially faster road.
It's a lot riskier.
It's a lot riskier, and we discussed that with him at length. I don't think I'm speaking out of school here or waiving any attorney-client privilege by saying that. We discussed all the aspects of the options open to him. And Rogan's he's a fighter, he's an activist, he cares about this a lot more than he's got his account back. He's got his account back.
Yeah, now.
No harm, no foul, right? Well, actually, there was plenty of harm.
Well, I mean, as someone who is also banned, I can attest to the harm. It is significant.
Yes. It is significant for people, but especially for people like you and Rogan, although probably even for me. I don't make my living directly from social media, and although I have a fantastic podcast, I've never had a sponsor. But it's an important part of my business, important part of my professional life. And but also as the judge as judges in every constitutional law case have said for the last several generations, if not earlier, even a momentary infringement of a constitutional right is harm. It is harm as a matter of constitutional law. So the Ninth Circuit blew it, as they are known for doing.
Yeah.
And we're going to with God's help to the Supreme Court. We're working on the cert petition, and that'll take us a few months, and we have a few months to do it. And there's going to be some interesting developments even in that process. We're very excited about what's going to be happening in this case.
That's awesome, because it's just it's a standalone of what's going on. We're going to get to everybody in the audience is like, please ask Ron about the Fox thing. We will. Go ahead, Ron.
I just wanted to point out that the case has been essentially ignored by the media, just as they've ignored the Twitter files. When I say the media, I still obviously mean the old media. the corporate media, as Michael Malice puts it, I think accurately. I tried to get people to use the term regime media, but it didn't
I
really
use legacy.
take. Yeah, that's right. Also, brand equity media. But in any event, that's why we're here. I mean, one of the amazing things about social media and podcasting, which is a form of social media, is that this is where people are really finding out what's going on. People who want to know what's really going on. They've got you. They've got. I'm not a newsbreaker as such. I'm a more of a pointy head. But I mean, gosh, Tracy, reading your analysis of, for example, of Missouri versus Biden, your head's a little bit on the sharp side too.
Thanks.
I'm impressed with the work.
Thank you. That means
Thank
a
you,
lot.
Susan.
That's the story.
Well,
It is far. It is.
Well, Susan, I thank you.
one of the things. Thank you, Frank, for that. I swear, if that didn't happen just now. One of the things that I love legal. I love covering legal. I love reporting on legal. It's just kind of something that I wanted to be a lawyer, Ron, before I decided to be,
happy and productive instead. I get it.
I don't know. That's debatable sometimes, but the difference, just to this Missouri v. Biden case that's ongoing, that is absolutely groundbreaking. I mean, it really is the most important civil liberties case in our modern history, I believe, is being litigated in Louisiana and is really not going well for the government at all.
It's really troubling. This is an increasingly troubling phenomenon, that where cases get heard under the same law,
federal court,
makes so much of a difference. And who brings the case makes a huge difference. It's entirely possible that if Rogan O'Handley had been able to sue in Louisiana, which he wouldn't have been, but if he had been, that he might have gotten a very similar result.
Yeah.
But in the case, in Missouri case, Missouri is the plaintiff and Louisiana is a plaintiff. And what you have is state governments bringing the claim. And one of the things, I wrote a white paper a few years back on about Section 230, which became an article that I co-wrote with Will Chamberlain on the old human events. Not the old human events, but the old human events.
I didn't know there were different versions.
Well, there was an old human events back in my day, which was a magazine, which kind of died because most magazines, especially magazines of thought, die unless some very wealthy person is subsidizing them. Then there was the one that Will bought the brand, and I was writing for them occasionally from time to time, and my wife, Jane Coleman, who's now with Legal Insurrection, was writing for them.
Jeez, it's a family affair.
And then Will brought on a partner, and Jack Posobiec is still involved because he branded his podcast with Human Events, and it's going great for him. But Will walked away from Human Events. He's not involved anymore. The editorial is, let's just say that Jane Coleman is now writing for Legal Insurrection and not for Human Events. In any event, human or otherwise, one of the things I observed in this article was that there's a judicial culture. Judges don't only decide the law based on the law or based on even their own personal biases, which everyone has. This is legal realism. There's a culture of judges which has been really intensified by the development of the internet. They're always looking over their shoulders at what other judges are doing. And one of the points I made was that I think there is a valid antitrust claim that is available against a lot of the media, the social media platforms, including probably Twitter, but that it's not going to happen if they're private antitrust actions, because if judges don't see states taking action, they're not going to feel confident to be the first judge to do something. And that's also true with what I really argue is essentially a consumer fraud type of claim, which I think has the best chance of success, In theory, if judges were really looking at this without this socialization process, it's a deceptive practice. If Twitter says to you, come onto our platform, help us build the platform, bring people on because you're Tracy Beans and people love your material, generate a lot of engagement, contribute content for years, but we can unplug you for any reason or no reason at all, and with no recourse.
Yeah.
After you've made that investment, that's a deceptive practice. And it doesn't matter whether you're paying or not. Let's put aside the issue of now people are paying $8 or $9.
IP though.
It doesn't matter whether you're paying or not. If you're the product and not the customer, that's cool. You're still a consumer because you have made that investment, you've made that commitment, you've signed. And amazingly, when I represented Laura Loomer, several versions of Laura ago, in Florida, and our case was dismissed. I sued on tortious interference grounds, and one of the reasons that the Trump-appointed judge dismissed the case was, well, you don't have a business relationship with Twitter. Wait a minute. They're relying on the terms of service.
A contract.
In this contract. But you, judge, are saying we don't have a business relationship? That's the judicial culture. It's a problem.
Yeah.
So, okay. They're making some progress on Biden versus Missouri, and that's Missouri versus Biden. That's fantastic.
So this case quickly, and then we'll get to Fox, because we have about 15 minutes. This case was granted limited discovery in search of the temporary injunction. It was
expedited discovery.
Expedited discovery.
That's the word you were looking for.
Yes. They were able to depose high-level government officials one step below department heads. The judge had originally granted them the ability to interview the department heads, but they appealed to the Fifth Circuit, and the Fifth Circuit didn't. They had a writ of mandamus at the Fifth Circuit. The Fifth Circuit didn't say, Judge Doty, you don't know what you're doing, you dumbo, listen to our order. They said, this is what you might want to look at doing. And then he did it, which to me is much different. And especially since the Fifth Circuit, Ron, was just involved in this whole Stanford kerfuffle and are just livid right now at the nonsense and censorship that's going on. I'm like, score one for Missouri v. Biden.
Yeah, the Fifth Circuit is the best place to be for conservatives right now. I don't think anyone's under any illusions about that.
Yeah, it's fantastic. So they get all that. Basically, this judge has ruled in favor of the plaintiffs every single time so far. So I get the naysayers saying, oh, this is never going to happen there. And I'm saying, we've already passed motion to dismiss. We're going to go to trial. The judge himself already said that they proved their case already. Then the judge said, this is just limited discovery. There's going to be a whole mountain that opens up after we get past the temporary injunction. So this case is true, and it's in the Fifth Circuit. So even if they appeal at this point, like they've gone judge hopping, they've gone to Virginia, and even the judge in Virginia on Jen Psaki, her deposition, they kicked it back. The judge in Virginia was like, I'm not going to rule on this when it's in a court in Louisiana and the Fifth Circuit's got a hand on it. What are you doing here? It was brilliant. So what do you think in terms of outcome? Are we in a good stance right now? Are we in a good position with this?
Yeah, and it's kind of funny because the Fifth Circuit, it'll make headlines on the coasts, which is what matters to the media, when they weigh in on something like an abortion pill. Mm-hmm. The issues that, but once again, Biden versus Missouri largely being ignored by the corporate media. It's going to be a big surprise for people when it goes the way it inevitably has to go. And as you say, the judge has sent every signal in the world about where it's going. And by the way, where it has to go.
Yeah.
Where it has to go. Because, and as you say, the issues are phenomenally important. This is not just a matter of whether or not somebody on Instagram or Twitter can post their little opinions or sell their supplements, or sell, or pitch their podcast. This is about whether human beings who happen to be Americans who are supposed to be the freest people in the world, can go onto social media and just as they might do down at the Quick Check and say, my sister got that, and then she took this and she was better in a week. Oh no, that's misinformation. That's disinformation. That's misdisinformation. That's malformation. That's misinformation. That's malformation. Hey man, that's our job. We're thinking people. The government doesn't decide that. And by the way, every time you've decided that, not every time, far too many times, you've been wrong.
No, and this is why the Restrict Act is in the hands of Congress right now, Ron. Make no mistake, because if the Missouri v. Biden case is ruled on the way we think it will be, and I'm nearly certain it's impossible to ignore. I'm going to hand you all the stuff, Ron. I'm going to get it to you after the show.
Thank you.
It's going to be helpful. It's impossible to ignore that this is happening. It's spelled out in black and white. This judge is not having it. If they win the case, it bars not only just the government, but the government-funded NGOs like the Election Integrity Project, like the Stanford Internet Observatory, like all these Atlantic Council-esque groups that take government funding from cooperating with social media companies at all. So they need another way to do it. Enter Restrict Act. Oh, well, if you take this away from us in our shadow type way, then we're just going to pass a law like the Patriot Act for the internet, and then we can do it all we want.
And that will be found unconstitutional as well. It is outrageous, and I think there's beginning to be a little bit of pushback among conservatives on Capitol Hill. People are realizing this is not a TikTok. People aren't calling it the TikTok bill anymore. People know what it's about. What's interesting? Everything's interesting, but one of the interesting things about Biden versus Missouri is that, as you said, it's in the Fifth Circuit. So when the inevitable appeal comes and the Fifth Circuit affirms, as it will, the government will then seek an emergency TRO, emergency relief from the United States Supreme Court. And that's where it's going to get interesting.
Yeah, that's when a censorship case will finally be heard in front of the Supreme Court with this one.
Yeah, because that's the thing. When the government asks the Supreme Court to review this kind of opinion, they hardly have a choice. They can't, especially if it's going to invalidate some statute or some really important regulation. And what I'm particularly intrigued by is how this court, which has avoided these cases like the plague, but which has nonetheless been pretty damn good on the speech prong of First Amendment, not so great on religion, in my opinion. I think, for example, the closing of churches, synagogues, mosques during the lockdowns was patently unconstitutional, and the Supreme Court, certainly in its previous iteration, was much too inclined to defer to the police power of the state. There's nothing in the Constitution that says that the First Amendment right to freely assemble and to practice one's religion is dependent on viruses or emergencies. And you had these rolling emergencies, statuses. I mean, there's a real problem there. But on the other hand, on the speech piece, certainly I know from personal experience, the Supreme Court has been very, very resolute on being nearly absolutist, maybe even further than I would go, not in my case, this Lance case. But, they've been very good. Both wings of the court have been pretty darn good on free speech. Will they recognize this as free speech? I don't see how they can. And especially if the Fifth Circuit sets it up the way they ought to, in their opinion, and they're very knowledgeable people over there. They know what they're doing. If they frame their decision, what I expect will be affirming the district court here, as it should be framed, the Supreme Court should weigh in the right way, and that could really change
everything.
It
really, it's groundbreaking. The case is really great. But thank you for saying that, because I've been saying it. I don't think people are really listening to me. I really don't, and it's frustrating. Ron, tell us about what you think about this Fox News settlement. And everybody's looking at it as a real big negative, which it is in my opinion. But I think it opens the door for people like me in a myriad of ways. So tell us, what do you think?
It's a negative. It's a shame. It's a tremendous amount of money,
Mm-hmm.
and I am positive that Dominion would never have been able to prove damages on that scale. Never. I don't believe they've been damaged at all. At all.
Yeah.
Yeah, this is
Three-quarters
all a
of a
slap.
billion
This is all a
dollars.
big slap on the. I'm sorry, I'm over here in the middle of the hurricane. This, I believe that this is all a big slap on the wrist for us to stop talking about things. It's not about whether or not, because what the hell was said on Fox News about this? They were reporting on what other people were saying. What claims were made?
No, it was never a legitimate case. Um, and look, Fox News, frankly, is not above suspicion. Their their management and their board include many, many people who, as you know, have not been reliable conservatives, and their coverage has had very, very significant gaps from the conservative point of view. It is carried on the shoulders of Tucker Carlson,
The
the
entire
great
network.
Tucker Carlson. That's right, the entire network. He obviously had no say and probably had no opinion. Well, I'm sure he has a personal opinion about this settlement. But if it weren't for Tucker, they would be out of business. Sometimes they have really good people on, like Harmeet Dillon. She's a regular contributor. They they don't tend to invite me on, so I know that they're missing something. But
They don't invite me on either, Ron. Don't feel bad.
yeah, well, probably for the same reason.
Then I'm in good company.
Nobody ever
Yes, you
talks
are.
to me.
Well, Frank, off the air, we're gonna have a little discussion. I think
You know what? If I ever asked me, Frank, you want to call in? We have a spot open on Fox tonight. I would not call in unless I had both the dueling landscaper and the power washer going on.
We
'Cause
can't
the landscaper.
hear.
Oh, you can't?
No,
It's terrible
Really?
over here. Okay.
Oh man, that is awful.
I don't hear any of the dueling landscaper. I don't hear the power
Oh,
washer.
we can hear. I thought you were saying you couldn't hear Frank. No, we don't hear a thing, Frank. We don't hear a thing. Uh, but if it makes you feel better that it's a landscaping related issue that is preventing you from hitting the top, go with that. Any coping mechanism. I myself opt for the pharmaceutical, but yours is probably healthier in the long run.
So was this now here's what I understand about the case. The judge barred certain what I guess you would consider exculpatory evidence from trial, which would have made it so that Fox could barely defend themselves in this if it were to have gone to trial. So Fox was feverishly trying to settle to avoid trial and the embarrassment that was likely going to come with it. But some people are saying, oh, they paid off Dominion so that now Dominion is flush with cash and can go do. But I'm not necessarily on that page yet with that theory.
Yeah, well, I mean, I don't know about a theory. I mean, though it's an empirical fact that they gave them $750 million.
Well, yeah.
And that is, but I don't think Dominion really needed capital. Like I think Dominion has plenty of protexia. The forces that are working with Dominion, if indeed there are any, I don't really know. I mean, I think there are lots of serious questions about what Dominion has done and how it's done it. But shut up. But you know, more to the real underlying point is that the judge's rulings were very difficult for Fox, and I'm sure they wanted to avoid discovery, not because they were involved in conspiracy or that there was some smoking gun of that would have demonstrated actual malice, but rather because no news organization wants discovery. It's just I mean, I can tell you I'm representing Carson Griffith, who was forced out of the attempted revival of what was it again? The one that the wrestler shut down. That magazine. I'm going.
Hulk Hogan. What was
Right.
it? What was the gosh, it's on the tip of my tongue. I can't remember.
Yeah, and I've been litigating this now for 3 years. The point is, they
Deadspin?
No.
no.
They had to pay him like 5 million or 10 million or something, some crazy amount of money for publishing pictures of him. Hulk Hogan. It was a big magazine that was like a gossip magazine.
I thought it was Deadspin. It
No,
wasn't?
no.
Okay.
Hold on.
Yeah, we have to do this.
I'm gonna find it.
Gawker.
Gawker. Yes.
So, Carson, who was a non-political professional journalist type, Daily Wire did this hit piece on her in order to bring down Gawker. And they have done everything possible to avoid discovery. I mean, appeals on appeals. You know, we've won everything so far, but media companies just don't want their internal workings to be revealed.
It would be terrible.
Not as much as I am not a gigantic fan of Fox's standards and presentation, which I'm not. Gee, I wonder why they don't invite me on. I don't think it's fair to compare them to the Daily Wire, which is essentially, a propaganda, really truly propaganda in a really malicious way.
Wait. The Daily Wire?
Not the Daily Wire. No, Daily Wire, my client. This is all being pre-recorded, isn't it, Tracy? The Daily Beast. The Daily Beast.
Thank you.
Between you and I hate my clients.
Well, so that goes back to my earlier statement about Harmony, Dhillon, and me. I mean, luckily she doesn't watch any of the content that I do. So
I'm like literally red from laughing at that. Okay, sorry.
the Daily Beast. So I wouldn't want to compare Fox to the Daily Beast. It's not a fair comparison. So I do think it's a bad development for Fox that they. I mean, if they would have settled for a mere $250 million, that would have been a bad development. This is a gigantic number, and it should scare people to think that media companies have this kind of money.
You know what I could do with that much money? Oh my goodness.
You know what I could do with 1% of that
like
kind of
tiny
money?
little fraction. You know what it does though is it opens up the door for those of us who have been lied about by the media to really have a precedent.
Why do you think it's not a precedent? A settlement's not a precedent. Why do you think it's a precedent?
You're right. I didn't think about it like that.
It's not a legal precedent.
Right.
It is a precedent in terms of how media companies deal with defamation. And yes, that in theory is, in other words, one of the things that these companies really don't like to do is to settle, because settlement is viewed as an admission that there's some vulnerability, whether it's actual legal liability or not. There's vulnerability, because we don't want to have our CEO or Rupert Murdoch
on the stand
deposed or on the stand. So it's a problem. And it's also a problem that media companies, which are usually meticulously protected by judges, here where the media company is on the wrong side of the political, tug of war, all of a sudden their ability to defend themselves is handicapped. It's an outrageous development. But as a data point in the trending of media vulnerability to defamation lawsuits, which have been made almost impossible in many states, such as New York. It is an important development. I do think you're right, actually, even though it's not a legal precedent, it is an important data point in the karma, in the overall approach here. But I do think we have to be careful to remember you're on the wrong side of that judicial divide, unless you're in Louisiana or Texas.
Florida sometimes. I mean, it all depends.
Florida is a funny place. The 11th Circuit is a funny place, and not always ha-ha funny.
Well, Ron, thank you for sharing your morning with us. Tell everyone where they can find your podcast.
Look for Ron. If you Google Ron Coleman Lawyer Podcast, whenever you Google Ron Coleman, you have to. The name of the podcast is Coleman Nation, one word. Coleman, but except that we couldn't get the domain name, Coleman-Nation. You can subscribe all the ways. You can find me on YouTube, but always use the word lawyer, or else you're going to get a very, very large bodybuilder who is not a lawyer as a result.
One of the best ever.
The best ever, who can barely get out of bed in the morning.
I know.
It's a shame. He doesn't deserve it. He didn't do anything wrong to anybody. But I am not big Ronnie Coleman. I am just not particularly small Ron Coleman, who is a lawyer. Follow me on Twitter at Ron Coleman, like my name is spelled with an E, dum-dum, RCOLEMAN.
You're
and
also
there you
on
can
Truth.
find all the links.
You're also on Truth Social.
I'm on Truth. You know, the new and improved Twitter makes it a little bit harder to care about truth. I'm also on Rumble, folks.
Like
The
we are
podcasts
right now.
all on Rumble.
Yep.
Just like we are right now. So go, you're on the platform. And after you're done listening to the next guest and the next segment or whatever it's going to be, the musical acts, you do musical acts and like, you know, magic shows and stuff.
We're not a variety show, Ron. We're
Remember variety shows. You're not old enough to remember variety shows. I'll give you. All right. A real pleasure talking to you, Tracy.
Thank you
We'll do it again soon.
Thanks, Ron. Have a great
See you,
day.
Frank.
Take care. Great to meet you.
Stay here.
That was fun.
Yes.
Now, hold on. I got to fix all the things now. Hold on here. Okay. I think I'm good.
You know, speaking of variety shows, Ed Sullivan is from my town.
Ed Sullivan? You mean like where
From my town. Yeah.
I love Ron, just to let everybody know. He's brilliant. He's a brilliant attorney, and he's brilliant. And
Well, that's the first time that I ever had Ron talk back to me. So that it was really nice interacting with him. I've only ever seen him on Twitter, and that was a really nice spot. I hope he comes back.
Me too. I'm laughing at the chat, not that. Me too, and he will. Ron Coleman on Twitter has a pinned tweet from August 2nd, 2016. Okay? It was like, what, 2 months after Donald Trump announced? Maybe?
Mm-hmm.
It says, I now realize the entire wretched system, left and right, Dem and GOP, MSM and Hollywood, is coalescing like antibodies to expel Trump. And it was true.
No doubt.
It was true. So now, as everybody knows, we won't have a show Friday, so we're going longer today with all